Great. Okay. Um, Thank you to everyone for attending today's program. For those of you who are joining us on a continuing legal education program for the first time, I would like to introduce you to SHALVA. SHALVA's mission is to support survivors of domestic abuse in the Jewish community through counseling, supportive services, and community education. As part of our community education, each October, we do a CLE program in honor of Domestic Violence Awareness Month. And this month we are super excited because we're actually partnering with Between Friends to offer CEU credits. Susan Peters is on here for a second. And is there anything you'd like to say about that?
Sure. Hi, everybody. Thanks so much, Vicki, for partnering with us to provide these CEUs for Illinois Certified Domestic Violence Professionals. So any of you all that are here that are wanting to get those continuing education units for ICDVP, I'm going to be putting a link in the chat right now, and I'm going to put it in again in a few minutes, and again a few minutes later, right? Keep putting it in there. Click it, and there is a sign-in sheet that it will take you to. I need you to complete that sign-in sheet. In that sign-in sheet, you'll be providing your email to me, and I will follow up with you via email about the other two steps for the credits, which is completing an evaluation and then paying the $10 fee. So just be on the lookout. In one moment in the link or in the chat, you'll see a link that you need to click. All right. Any questions, feel free to email me. I'll put my email in the chat as well. Thanks so much, Vicki.
Great. Thanks,
I'm really
Susan.
looking forward to learning from all of you today.
Thanks. Okay, without further ado, I want to welcome everyone to tips for obtaining and enforcing orders of protection. We are doing this in honor of Domestic Violence Awareness Month, and I would like to introduce our panelists. We have Judge Judith Rice, who is the acting presiding judge from the Domestic Violence Division of the Circuit Court of Cook County. We have William Evans, Patrol Sergeant with City of Highland Park. Sylvie Manister, the Assistant State's Attorney with the Cook County State's Attorney's Office. Andrea Mushin, partner at Schiller, DeCanto and Fleck. Aileen Robinson, the Assistant Director of Crime Victim Services with the Chicago Police Department. And our moderator for today is Scott Zimberg, who is a principal at the law offices of Scott Zimberg. I will also be using the chat function today to have, to put information in during the program. But at this point, I'm going to turn things over to Scott, and I'm going to mute myself.
All right, well, thank you very much, Vicki, for thanks to SHALVA for hosting this CLE. I think it's going to be a great CLE. And I know the biographies of everyone on the panel was included and sent out, and I would encourage everyone to read those because we have a very qualified panel, and I'm excited to work with them on this program. We're going to cover a lot of areas, and as a practitioner, and I know there's a lot of practitioners who are joining us, we know how to get an order of protection and file up order of protection, go to court, but I think there's a lot of areas that happen outside of court that we are not hands-on with and that other people are handling that I think will be helpful to learn about so that we could advise our clients and parties can learn a little bit as to what they may need to do or what they may need to, whom they may need to contact to enforce orders or if difficulties come up with orders that are entered. We're going to start off with, we're going to go through the panel and everyone's going to hopefully chime in and give their insight on the various questions. But we're going to start off with Judge Rice today. And the first question I had is, if you have a client or if there's a party that cannot access the court during normal business hours, can you explain? I know that the hours were recently expanded and how that is working with the domestic violence program.
Thanks, Scott. This was something that was really important to the DV community to expand our hours and court access. It was also important to our Chief Judge, Timothy Evans. If you recall, in October of this year, Judge Evans pulled together a DV committee, and it was led by retired Judge Grace Dickler. That committee consisted of civic leaders, attorneys, judges, and elected officials that came together that made recommendations to the circuit court for domestic violence. And one of those recommendations is that we start issuing orders of protection 24 hours a day. We didn't have the judges or the staff to move quite to 24 hours, but we did move to expanded hours. And so those hours, you'll see I have some slides that'll come up later that we are now issuing orders of protection after court hours. Our normal court hours are 8:30 to 4:30. We now issue orders from 9 p.m. to 3 a.m. during the week, Monday through Friday, and from 1 p.m. to 6 p.m. on Saturday and Sunday. So individuals can file with us electronically. And again, when I get into my presentation, I'll show how you do that. And we have a judge on duty. The hearings are conducted over Zoom, just like we are now remotely. Hearings are done in 10-15 minutes, and the orders are emailed out to the litigants. So it's been a very successful program over the last several weeks. It's a 17-week pilot going to January 1st, and we started again right after Labor Day, September 6th.
Okay, thank you. And what we're going to hear about first is serving a respondent once an order of protection is issued, which is and we'll hear from, I think, from the law enforcement members of the panel, as well as you, Judge, that an order of protection is really not enforceable until the respondent is served with the petition for order of protection and the emergency order that was entered. So getting them served, as quickly as possible with the, is very important. And I wanted to ask you if you had any insight or some tips for practitioners or for litigants when they are appearing in court so that service can be effectuated quickly.
Vicki, are you going to bring up the slides? Can you bring?
I can. You ready for them?
Yeah, go ahead.
Wait. I am ready to share my screen. Here you go.
Okay, you can keep going. All right, so I don't always like to call them restraining orders, but this slide is just to show that we're now issuing 5 different types of orders at 555 West Harrison and throughout our system. We issue orders of protection for people that have a domestic relationship with each other, which means your mother, father, parent, child, dating relationship, living together, uncle, aunt, etc. Then we're issuing workplace violence orders. That means any employer can come in and get an order for an employee or a customer that's creating violence in the workplace. We're now issuing the firearm restraining orders for those individuals that are getting firearms and a litigant or the police department is able to show that they're a danger to themselves or others. We have the stalking no contact orders and the civil no contact orders, and that's for rape or unwanted sexual contact. So we can go on. Those are the types of orders that we're issuing. The main things that the sheriff needs is respondent's home address, and it's important to include an apartment or unit number. Lots of times the sheriff gets out there, it is a huge multi-unit building, they don't know where to go. You've got to include apartment or unit number. If they don't know the respondent's address, use a relative's address. You'd be surprised at how easy it is to find a respondent if they go to mom's house or dad's house or sister or brother's house. Also, people can be found at work. The sheriff will go to the place of business if they know the work hours to serve. And it's also important to enter a complete physical description: age, race, height, weight, hair color, hairstyle, and eye color. Is the person bald? Do they have some type of hairdo, hair color that would stand out? Tattoos are important because a lot of times the sheriff opens the door and say they are here to serve John Doe, and John Doe says, "Oh, it's not me. But if John Doe has a tattoo of an eagle on their neck and that's in the order and they see that, oh, yes, it is. Yes, you are John Doe. Respondents' phone number and email. Sheriffs often call the respondents. They meet us here and they're able to serve them. Date of birth. This is the most important piece of information that has to be known. These orders cannot get into leads without a date of birth, and they will not go into leads or be served if there is no date of birth. So that's a very important piece of information. You can move on to the next slide, Vicki. If there are issues or more information can be given to the sheriff is asking first that you email it to the sheriff's office at ccso.protectiveorders@ccsheriff.org. That is their email that goes directly to the sheriff's office where they're serving process. Or if you want to call them, they're available all the time at this number, 312-603-3714. The sheriff's office is serving up in the northern suburbs, particularly the Skokie district, until 10 o'clock at night. And I am remiss in not thanking SHALVA and Vicki Rifskin for putting this together, because you have a very active area, and what you're doing to get this information out is phenomenal. So I want to thank you for inviting me. But your sheriff has assured me that they're working until 10 o'clock in your area. Next slide. This is the sheet where all of this information can go. Each attorney, the more information you put on here, the more likely that the sheriff is going to be able to serve. And any caution information is really good. Sheriffs love that because they can know what they're running into. Likely to carry weapons, history of mental illness, etc. So this is a test case here. You can see how the information is filled out, and even vehicle information. They see people getting in and out of vehicles. They can approach them if they know what type of vehicle that they drive. So you can move on. I want to go back to your question, Scott, about after hours work. That slide references one of the partners that we partner with for our after hours work, and that's Illinois Legal Aid Online. And so the way that someone approaches us after hours is they get on the website, Illinois Legal Aid Online, and they are able to do a point and click program. And it's written in plain English. I would suggest all attorneys and everyone get on and try to make a filing on this. So you can do a test filing, or you can go through it and then not enter it to file to see how easy it is. So anyone who has a computer, our staff had their sixth graders do it, their eighth graders do it just to test it out. And I did it. So if I can do it, anybody should be able to do it. You go to the next slide, if you can. So here are the links to Illinois Legal Aid Online. This is the site where you are referenced to go to if you want to file an emergency order of protection after hours. When you get on that site, you're prompted to go to the next question. The questions are your name, the respondent's name, their address, your address, all of the questions to fill out your petition. Next slide. For those that don't have computers or have difficulty filling out the petition, or just don't understand, what's a petitioner, what's a respondent, or any of the legal terms, they can call someone that we made a relationship with through the county, and that's CAWC. They're an advocacy group in Cook County that has a long-standing relationship with Cook County that stands for Connections for Abused Women and Their Children. They have staff during the hours that we're taking remote filings. They can safety plan with a survivor or victim. They can get them any services they need, and they can also file the petition remotely. So they have access to computers where they can file online. Go ahead to the next slide. Here's their contact phone number. Next slide. And again, the after hours pilot is 9 p.m. to 3 a.m. Saturday and Sunday, 1 p.m. to 6 p.m. This is our Zoom information. You can reach the judge during that time with this Zoom information. But you have to have a case. It's not an open Zoom for our judges at night. But they are available during those hours. Next slide. This is the process. The ALEO form is submitted through their system. Once the petitioner hits send, an email goes to the clerk of the court. The clerk of the court picks up the filing. The filing is a point and click form. All of the form is done for the litigant. The clerk picks up the filing, calls the Zoom coordinator on our end. The Zoom coordinator contacts the judge and says, we have a case. The clerk has initialized the case. And the Zoom coordinator also calls the litigant and says, the judge will see you in 10 or 15 minutes, gives them the Zoom information. The litigant calls onto the Zoom. They conduct the hearing. Hearings usually take 10, 15 minutes. The ex parte hearing is done. If the judge issues the order, the judge signs the order using Adobe Pro and sends the order back to the clerk for entry. The clerk then enters the order, emails it out to the litigant, and then sends it down to Leeds. Leeds has clerks at night entering these orders within an hour onto the Leeds system after they've been entered, and then they're batched the next morning and service begins. If the judge denies the order and dismisses the case is simply dismissed. The litigants get a copy of that. The judge can also deny the emergency order, but move the petition forward so the person can prove a plenary case, and they will get a copy of that, and the judge sends the petition into court within 21 days, and the litigant gets a copy of that petition and is notified what courtroom to return to. So the litigant may be returning on an emergency case or on a petition only. So that's the process. It's all electronic, all remote, all in the evening. Next slide. All right, and this is an idea of what some of the summonses look like. Keep going. Keep going. And this is just a reminder, Senate Bill 399 states that DV victims can keep their address private, but they do have to create an address, a substitute address where records and IDs can be sent. So the other side has to be able to communicate them with them legally. So they have to create a substitute address. Next slide. And finally, we can serve process in court. Sometimes we have respondents that find out about a case. A relative emails them. We think that someone's filed a case against you, and they do show up in court. So we can serve the respondent at the next court date. So this is just a reminder that there is an order, general order, the state of Illinois, that the respondent can be served in open court as well. And I think that's it for me. That's our DV hotline. Anyone wants to call the state to get more information about this? The domestic violence community does provide information about our after hours program as well.
Okay, and I know with regard to information, also I've in the past photographs have been helpful with the sheriff as well, sending them photographs when they're going out to serve respondents as well for the reasons you mentioned, Judge Rice. I wanted to bring Sergeant Evans and Aileen Robinson in on the next topic with you, Judge Rice. In cases where an emergency order protection is entered and there's a minor child involved, and minor child is needs to be for lack of a better term, recovered from the other parent or the respondent. So there's a matter of somewhat urgency. Is there some sort of expedited process that the sheriff's office may use or that law enforcement may use if they are given a copy of that order protection? And I do want to qualify one thing. As you heard, Sergeant Evans is from Highland Park and Ms. Robinson is from Chicago. And I know they're answering specifically for their jurisdictions, and other suburbs or other cities may probably have similar procedures, but there may be slight differences. So just want to remind everyone they're answering for their specific jurisdictions, on these questions. So I don't know if any, maybe Sergeant Evans wants to jump in on that particular question. If there's an order protection and minor child's being held and needs to be recovered from a respondent.
Yes, first I'd like to thank you guys for inviting me. I really appreciate it, and Scott for hosting. Oftentimes, if the orders, unserved orders, would go to the Lake County Sheriff's Office, it's very much more. They can expedite the process by bringing the order straight to us, and then we would attempt to facilitate service, return the child to where it should go, or something like that, whatever the order would say. So we would.
Oops. I think Sergeant Evans froze. He's excited to answer that. Maybe Ms. Robinson, you could jump in as how Chicago would handle that, and then we can come back to Sergeant Evans.
Sure. I do want to make one quick note on the slide that listed the hotline number. There is a typo in there, and I didn't want to forget in case anybody doesn't know the hotline. So it is 1-877.
Thanks for catching.
636338, and that's 1-877 to NDV. And we're having problems with the chat, but we could post that in the chat a little bit later.
Thanks
So
for catching, Aileen.
I can recite that number forwards and backwards. If I'm ever on Jeopardy and that's the question, I'm going to win. But to answer things, and yeah, Scott pointed out, so sometimes things differ a bit from jurisdiction to jurisdiction. But with issues with minor children and returning minor children in Chicago, during regular business hours, most of the time that responsibility goes out to the Cook County Sheriff, and those are expedited and they handle them very quickly. With the expansion of the extended hours in the pilot program, that unit does not work those expanded hours. So that will go to my department, which is the Chicago Police Department. Anytime we have issues regarding minor children, that is absolutely a priority for us. So you can expect that that is going to be something that is going to be signed immediately. You have to keep in mind what's going on, where things are going on. And to that petitioner who's waiting for the return of that child, it may seem like it's a forever process. But also to keep in mind that law enforcement, we can't pick up a child and transport a child without a car seat. So we have a couple steps to go through as well, but please understand anything regarding minor children is going to be expedited immediately. I also want to say that any law enforcement jurisdiction can facilitate the return of a minor child. So just because this might be during the day when the Cook County unit normally would have this responsibility, it doesn't mean that we couldn't be driving down the street and get flagged down by a petitioner who said, hey, I just got this order and in the building is the respondent who has my child that's supposed to be returned to me. So just to be clear, any law enforcement agency can and should facilitate the return, but this is how the normal process would work for us here in Cook County, more specifically in Chicago.
Okay. And Judge Rice, do you have anything as it relates to the sheriff's office on how they respond when they receive orders from your judges with regard to children?
Yeah, well, one of the greatest things is we have a sheriff's office right here in the building that when litigants do get an order from one of our judges here, they can walk right into the sheriff's office here and coordinate with them a return of a minor child. And that's often very helpful for them. And you know, Aileen is often here and works with us as well as a partner to us.
Okay. And I think we still are, hopefully Sergeant Evans will get back into our group. I'm sure he's trying. I wanted to shift also to the issue of when emergency order protections grant the petitioner exclusive possession and how a petitioner can go about if they don't want to wait, because oftentimes I think victims do need to, you know, they've left the house or they've gone to a friend's or a hotel and they want to get back to the house with, you know, with the child as quickly as possible. Once they get that order from court, before the order is even served, can they do anything with local law enforcement to enforce that order? And I guess I'll start with you again, Eileen.
Hi. So first I want to clarify, and probably most folks know this, with the exclusive possession of residence, before we even send folks to 555, we have to make sure that they're entitled to get exclusive possession. So I know a lot of times we say, oh, go to court and get exclusive possession. And we send a lot of folks to court who aren't entitled to. But if someone has an order, let's say they just left court, they went straight home, the offender's there, what they can and should do, if they feel so inclined, call 911, call from a safe location. So please do not stand. Don't direct someone to stand in front of their residence, a corner or a place close by of safety. And they should state that I have an order of protection that grants me exclusive possession and that the respondent is currently in the home. What will happen is, I just lost you guys. Okay, you just came back. Whew. So what will happen is car will be dispatched. And I want to be really clear, for any type of domestic violence related call for service, whether it's enforcement of an order of protection, whether it's a battery in progress, to always be sure that you counsel folks to say domestic violence or state that relationship, which makes it a priority one call for service. Same thing as shots fired. So someone calls from their safe location, the officers will show up, talk to the petitioner, check in with the respondent, verify, and by that time, the order should be in leads. What will happen is they will serve the respondent by short form at that time, and also explain to the respondent what the remedies are. So for example, exclusive possession of residence, they will make sure that the respondent leaves the property and understands that if they are to return, absent a change in the order, that they are subject to a mandatory arrest.
Okay, and it looks like we have Sergeant Evans back. Welcome back.
Before we move, I don't want to move off that point though, Scott.
Sure.
It is really critical that that survivors understand that they should not be the ones to serve the order and to try to get the person out of the home. And they should not go back to that home alone. Our most recent person who lost their life due to, I don't know if you remember the case where the young woman was shot at Target. That is exactly what happened. She went to the home to move out, and I don't know if it was an issue that no one went with her or she didn't know where he was. And he came back to the home and confronted her. And so we really need for people to understand that they've got to get an advocate to go with them, a friend or family, or get to the police, to have the police go in with them to serve the other side and serve and help them to get that person out of the home and get them served. It's critical because that kind of safety planning really has to happen.
Sergeant Evans, I know you you may not have heard the responses on the last one, but I did want to. There's a couple terms that have been used earlier, and I thought it might be a good to just explain a little bit. leads. I know we refer to leads, but some people may not be exactly know what leads is. And then also the short form that I think was mentioned earlier, what a short form service is as well.
Yes, sorry for the technical difficulties on my end.
No worries.
LEADS is an Illinois system. It's called the Law Enforcement Agency Data System. And what that does is it essentially is it holds all records in Illinois for various things, warrants, licenses, officers, or when they say they're going to check a license, check a registration, they're able to that information goes through LEADS. Additionally, orders of protection, other orders, firearms restraining orders, variety of things are entered into that database. So officers have access to that at all times through their terminals that are generally in their cars. It also hooks up with what's called NCIC, which is the national system that shares records through all 50 states. So if someone would have an active order of protection from another state that's entered into NCIC, it would also make the officer aware of it as they run it through LEADS.
Okay. And did you mention short form as well?
Yes, the short form, if an officer comes upon someone that has an unserved order of protection, they're able to complete the short form, which provides the respondent notice of the order of protection. It provides all of the information as to what's allowed, the provisions in terms of contact, whatever is, has been established for that particular order. And then they serve notice to the person. And then it's incumbent upon that officer to enter it into LEADS as served. So then any officer that would encounter the respondent later would know that this order has been served, and they could, if enforcement would be necessary, they'd be able to do so.
Okay. Flipping back to the exclusive possession, or someone has possession of home, in the situation where the petitioner does contact law enforcement as advised by everyone here, you go to the house and the respondent is not there, but potentially is coming back and hasn't been served. What is recommended with regard to that the petitioner? I think, Judge Rice, you did allude to that a bit about, making a plan and maybe not taking the step of moving back in just yet. But I'd be curious, from the law enforcement on the recommendations on what you would recommend to the petitioner, and, should they call, call you later in the day and try that numerous times until the respondent is notified.
Well, that could put them potentially in a situation of danger, like the judge alluded to. Having a safety plan in place is very big. If we would feel the person's going to come back to the residence, maybe not follow the order or something like that, we would try to establish something, put something in place so the petitioner is safe, make sure the family's safe. And then maybe if there's something we could do, we would have resources. We have a full-time social worker that we work closely with. We also have the Highland Park Highwood Legal Aid Clinic. Sometimes we kind of have them on speed dial for particular things if we have an emergency situation like that. If we have to get someone housing or something like that, we have the resources to be able to do that.
If I could jump in for a second too, as far as calling 911, a lot of times victims are hesitant to call 911. I always say call 911 and let that call taker determine if it's an emergent issue. If it is not an emergent issue that needs an emergency response, they will transfer that caller to 311. So also in respect to the situation that you presented, Scott, we come out there, the respondent's not there. If the respondent comes back and forth 5-10 times that day, the victim should be instructed to call every day, or if they let their neighbors know. So part of safety planning is let your friends, family, and neighbors know when it's safe to do so, and let the neighbors know that if they see the respondent there, that they absolutely should call 911. Again, it's a priority call for service. It's a domestic related crime. We have a system in place in Chicago too that can be more individualized to a victim. So every single one of our police districts has what's called the domestic violence liaison officer. So you just have to call the district, or you can go into the district normal business hours that are there. They're also there on weekends, and say, this is what I have going on. This is how I need help. I need help with safety planning. The respondent is kind of eluding service, and we could put a special attention on someone's house. So there's different tools we have in place. We're also fortunate at CPD to have, and I was going to use my fingers to count because I can't keep track of my team. I have 4 domestic violence advocates who can give even more help than a domestic violence liaison officer. We have a special program for victims of Chicago police officers. So if you're working with someone and their abuser is a Chicago police officer, there are some really, really unique challenges to those types of situations. And so we'll see a lot of challenge around this issue. Again, you would give me a call at my program and we would assign someone. And then I have 3 advocates who work with victims of non-fatal gun crimes, including those that are domestics. So again, Highland Park and all the larger municipalities around here are going to have additional supportive services, so that when someone is not in that emergency situation, to reach out to law enforcement and access whatever tools and support that we're able to provide.
Okay, my next question is the situation where maybe there's no minor children that need to be recovered, no exclusive possession, but a lot of times clients who obtain order protections will ask me, should I go to the police and give them a copy of my order so they have it on file? I get asked that a lot, and I would like to hear from you guys if that is helpful in any way, or that increases any type of protection or any kind of awareness, or if it's necessary at all.
I would say officers are able to access the order through leads, so they're going to know if they run across the parties. But dropping off an order, sometimes we might not instantly know an order was obtained by someone in town. So giving us that heads up kind of provides that extra layer of support, I would think. And we would let officers know in turn, okay, there's an active order here. There's potential too, it might not have been served by us, so we wouldn't know, like I said, right away. So I don't think it's a bad idea. We keep all of the orders that do get dropped off in our dispatch. So the dispatchers have instant access to it. We would put an alert on the residents, so responding officers would know, and with the parties involved, so they would know there's an active order, just in case officers they might not have that information instantly.
So Chicago's a little bit different. We do not have the capacity to bring in those orders. And then there's also the concern of giving someone possibly a false sense of safety, since we aren't able to manage such a large number. But what I do want to say, and we're running across this more and more, for foreign orders of protection. So someone who lives in another state who has an order of protection, sometimes remedies and the process and the policies are a little bit different. So what we do for those orders, which will make it easier for law enforcement, is to encourage folks to go down to the clerk's office with a copy of that foreign order. And the clerk is then able to enter it into leads in a way that Illinois law enforcement can understand it and enforce it, and it is then entered into the system. The respondent is not notified, so sometimes victims are nervous that the respondent's going to know it was entered into our database, which the sergeant explained very well. It's just for law enforcement. You all couldn't access it, so there's no notification. And what it really does is it helps us in a quick and efficient way to enforce foreign orders, where if it's something really unique, we would have to try and contact that jurisdiction. And at 3 o'clock in the morning, it's sometimes really hard to be able to do that. So again, I just want to encourage folks who have foreign orders of protection to go to the clerk's office and have them do that legwork so that it could be put into the lead system, so we are able to quickly and efficiently serve it and enforce it. I'm sorry, we can't serve orders outside of Illinois. I will back up through the normal short form process. It's another process, which is another training, but go to the clerk's office.
Okay.
And also, Scott, I'd like to also encourage people to, we also protect employment addresses. Oftentimes people don't give the orders to their employer, and they should, so that if their employer has security available in their building, that their building security knows what's going on, because that's often a place where an abuser may show up, is the employment office.
Okay, and I would assume that also applies to, like, I'm sorry, to minor.
I was about to say the same thing, but I would also sometimes, depending on where you live in terms of what who's around in your community, if you have a neighbor that you trust or something like that, I would also let them know that this is happening, just so you know, kind of the more people who have eyes on your situation, the better. I understand sometimes you don't want to let your neighbors know your business, but it's important to let people know, because if they don't know, then they don't know that something could be wrong either. And so they won't, if they see the offender's car or something like that, those are people that can also be on your side in terms of letting you know what's going on. So you don't have to, you don't know that he's there, or that the person's there as they're knocking down your door, but you have, there's always, I feel like everyone has a neighborhood watchdog in there. In the vicinity. You should give that to that person if you trust them. Obviously, you don't want to do it if you don't trust them.
Right. And I also, it applies to the children's schools and things like that. So if the children are protected parties as well. And I'm glad you jumped in, Sylvie, because I'm starting to get into the areas of enforcement and prosecution of violations of the order of protection. First question I had starts with, again, with the law enforcement. And I also want to mention, if there's any questions that people have, I know some people have started sending them. We're going to save some time at the end to ask as many as we can. But if somebody has an order of protection and they, let's say, for example, as Sylvie suggested, a neighbor says, I saw so-and-so, they drove by the house last night a bunch of times. I think, they've been around. What should the person with the order of protection, the petitioner, do in that situation once they get word about that? We'll start with Aileen.
I'm sorry, Scott, can you rephrase that? I lost you a second.
Sure. If somebody with an order of protection, they get a call from their neighbor that last night the neighbor saw, the respondent driving back and forth in front of the house or walking around, or the person is knocking on the door, even the most extreme circumstances, pounding on the door or trying to get in. What are the steps that happen, from that point forward with and what should the petitioner do in those situations?
So a couple of things. If the neighbor tells the petitioner the next day, the petitioner should call 311. It's not an emergency at that point. They should call 311 to report what happened and to get a case report for that violation of an order of protection. Ideally, the neighbor calls 911 at the time that they see the respondent on the scene. And there's a couple of things to know about that. Number one, you can call anonymously. So you could say my neighbor next door has an order of protection and I see the respondent, or the offender is there. The other thing that gets really confusing is sometimes we have protected addresses. And that means that address is protected whether or not that victim is at that address. And that gets really confusing where people think, well, I'm not going to call 911 because the victim's not there. So also really need to clarify when we're doing safety planning and we're talking to petitioners of orders of protection and they're sharing their information with neighbors, friends, family, that if there's a protected address and that respondent is there, for Chicago, that's an emergency. Call 311. Call 911.
Okay. Is it similar in Highland Park, Sergeant?
Yes, we would want to know about any violation, any emergency, of course, call 911 right away. I think the big thing to note also is that our officers or our supervisors aren't determining what considers is a violation. If there's some type of third-party contact provision, we're writing a report right away and we're getting, if someone needs to be arrested, of course, for the enforcement, we'll do that. But if there's, we're notifying the state's attorney, getting them involved for screening the allegations, the case, and we're handling it that way. So reports are being done right away. If someone needs to be taken into custody, then that case is getting screened right away.
Okay, and Sylvie, why don't I jump to you? Like, if you're contacted by a Sergeant Evans or somebody from Chicago, how are those cases then evaluated from a prosecution standpoint?
Well, so depending on whether or not the defendant or offender is arrested, if the offender is arrested, they get charged and go through bond court, and that kind of the determination is made at the time of the arrest. Obviously, if the defendant, a lot of times the offender is not on scene, so they have to go through a screening process. Obviously, I don't know what those steps are in Lake County, but in Cook County, for example, at 555, there's a whole screening unit where you take that, the Chicago police have a specific domestic violence form. They give you a RD number and you take that form to 555 West Harrison and go to screening, which I believe is not still on the first floor, or you could probably do it via Zoom. I'm not too sure about that. In the suburbs, it's a little bit different where, because, the volume is different, at least in Cook County, like I said, you go to the police department and they give, in the Markham suburbs, they give you something called a packet. And the packet consists of reports, possible complaints, and a background, and any other relevant information that the police deem necessary. And the packet is sealed, and the victim will take that packet to the Markham courthouse, and the state's attorneys will go through kind of a screening process to determine if they are able to file that charge. Obviously, different factors go in terms of whether or not they decide to make the charge. And this is obviously for misdemeanors. For felonies, it's a whole different process where in Cook County, where the police would have to bring that charge to felony review if they believe it's a felony, which is a completely different. It's not, the victim is not involved in it as much as the police would be at that point.
Okay, in a hypothetical situation, unlike, somebody pounding at the door or on scene, let's say, for example, the person with the petitioner has a no contact order. The respondent's not supposed to contact by any means, but the petitioner is receiving non-threatening text messages from the person, every day, a few text messages just with random thoughts, but not threatening, or random phone calls and hangups, things like that. How would the petitioner proceed if that is occurring and there's a no contact by any means in the order of protection, and how is that processed by law enforcement?
Obviously, like whether or not law enforcement, I mean, I would tell law enforcement, I would tell them to still go to law enforcement no matter what the violation is, whether or not they believe the violation. It's not for the victim to determine the violation, it's for the legal process. Obviously, whether or not those charges are that we could charge those are, the cell phone and stuff like that is really complicated because, we don't just have to prove that the text was sent. We have to prove that the defendant and offender was the person behind that text. So those cases are a lot harder than people think to charge because, an offender can say, and I'm not saying that this is, there's a difference between like real life and, life inside the vacuum of the criminal justice system. Is it more likely than not that the defendant or the offender is behind his or her own cell phone? Absolutely. But that doesn't mean like that's proof beyond a reasonable doubt. So those, and I do think that the police departments have made very great strides in the past like 5-10 years in learning how to combat those violations in terms of proving what we need to prove. But those take a lot to prove. You can't just say it was, the victim says like, oh, this is the phone number. This is obviously phone calls are different because you have a voice. There's more of an indicator of who is behind that phone, but they're more complicated than I think most people think because you have to sometimes you get IP addresses. There's location data, things like that. So,
Sure.
I think you shouldn't call the police. I absolutely think you should call the police, like Ms. Robinson said. The reality is just if you think there's a violation, call the police. It's not for you to determine whether or not there's a violation. It's for law enforcement and the prosecutor's office to determine whether or not they can prove that violation. And then you also make a paper trail to make sure that they know what's going on. Because sometimes you can take things. A lot of little things can lead to a bigger charge.
Sure. So if let me back up for a second, then if they do contact either Chicago or Highland Park and say that they're getting these messages, what would they be advised, or what would happen if they did that? Maybe start with.
I think it determines whether or not sorry. Are you talking about? Okay.
Yeah, I'll go directly to the source.
So our process will probably be a little bit different than Highland Park's. But first I want to stress, if you have no contact by any means and that respondent sends you a text message that just says hi or says how are you or I love you or I miss you, that's a violation. So I want to be really clear. It doesn't have to be threatening in nature. It doesn't have to be negative. Any contact. And we're really clear. If the judge says no contact by any means, that means no contact. With technology, it becomes a problem. So I wanted to focus a bit more on technology. So if you're getting contact by phone, email, text. I'm too young to know about, too young, too old, Twitter, although if you're getting contacted by technology, what we want folks to do is to call 311. And here's kind of what it looks like. And here's what can be frustrating and also speaks to what Sylvia is saying. So in those instances, if we know that that person is the person sending it, then in that case report, they're going to be listed as the offender. But many times, especially with technology, that victim knows it's the offender, but there's no proof at that time it's the offender. So what our case reports look like at that time is going to be the name of the victim. For offender, it's going to say unknown because we don't know. However, in the narrative, the officers are going to document victim has an order of protection against John Doe. Victim believes the offender to be John Doe because of the following. Came from, sounded like him, maybe was from a buddy, whatever that is. The caveat to this electronic harassment and other kinds of harassment using technology, when I said call 311, let me also say, but if someone's saying, I'm going to get you, I'm going to kill you, if they say, I see you're wearing a blue polo today, those are calls to 911. So again, it's so difficult to give anyone a flow chart on when to call 911, when to call 311, what to report. So always, when in doubt, I don't know if I'm sure my colleague is going to say the same, call 911, let us figure it out, let us document it. In those types of cases where we don't know on the scene or at the time of the report who that alleged offender really is, then we have detectives who follow up. So sometimes victims get upset when they see a case report and say, what do you mean it's an unknown offender? Well, at that time, we can't be definitive in knowing who made that contact. However, you've got your report to take back to the court. And at the same time, we have specialized special victims detectives all across the city who not only do DV, but who do technology crimes. And they're the ones who are going to help us determine and work with the state on where those threats came from.
Sergeant Evans, anything different, how that would be handled in Highland Park, the text messages or phone calls?
I think the only difference is as a smaller organization, our officers might be handling it kind of.
It looks like maybe having
Smaller kind of if
it looks like you may have tailed off there. Well, I'll follow up with a question. Judge Rice, I do have a question. If, well, I think what we're hearing is that there may be, you can make a police report, but maybe there's not enough evidence to, that the state is not going to press charges for a violation. Is there something a petitioner can do if they have an order? There's a different burden, if they're coming before the court in domestic violence, anything that can be filed in relation to a domestic violence order if somebody there's violations, but maybe doesn't give rise to a criminal charge.
Sure. They can always file in a civil order a rule to show cause. They can file a petition for a rule to show cause, and they can allege the violation and bring the matter before a judge on a rule to say that the judge should hold this party in contempt of court because they're violating the order. And the statute does allow for that. And we do see that happening. Our judges don't prefer that because they prefer that these orders are handled by the police and criminally prosecuted when they're violated. But if there are things that are happening, as Eileen said, that don't necessarily rise to the burden that law enforcement may want to proceed on it, we can, the litigant can proceed in a rule to show cause. I'm always shocked at how much technology has changed our world and how many times people get these fake phone numbers or burner phones, and they're calling on these phones that they can't be tracked back to the litigant, or they're making fake Facebook pages, etc., in an attempt to continue to go after the petitioner. It's just amazing what technology has done to this. But certainly it can really put a respondent on notice if a petitioner files a rule and brings the respondent into court and say, I know by what you're saying that this is you doing this. I may not be able to attach it to you, but this keeps up, cut it out, you know, and
Sure.
we do have that happening all the time.
Okay, Sylvie, if a petitioner is, you know, is trying to enforce an order, is there any option they have to go directly to you or directly to the state and ask that charges be brought or that it be reviewed in some way on their own?
No, you have to go through the police department. It's the police department's role to investigate, and then they take it to us. There's no direct way. I mean, I don't know and as Judge Rice said, you know, there's a lot of remedies. Just as another point, there's a lot of remedies in these orders of protection that are not criminal charges. There's only, I think, five remedies that are actually, you can violate the order of protection criminally. And that doesn't mean that you shouldn't, like everyone said, you should always go to the police to document those. It's important that a non-party documents those instances, not yourself or somebody else. But there's, you know, but I would have the police investigate it first and then come to our office through the process. But, you know, and sometimes that process is really frustrating for victims, and it's completely understandable because usually when these things are happening, people believe that their lives, you know, their lives are upended. And so even though, you know, it seems like it takes forever, we still have to follow the law in terms of what happens. And if we don't do that, then the case is going to get thrown out. So it's important to, you know, try to go through the right processes so we have everything documented correctly, so we're able to hold the person accountable.
And if somebody is convicted of violating an order of protection through your office and goes all the way through and they're convicted, what is the penalty for somebody who violates an order of protection?
So the first, let's say you're arrested the first time and you're actually convicted the first time, that is, you are eligible for supervision. That's a Class A misdemeanor. But there's, and that's technically not a conviction, but it is kind of a period of probation that doesn't have like a remedy, I guess, at the end. You also can get probation or the max is 1 to 364 days in jail. Now, let's say you get probation or you serve jail time for those, for that charge, then the next time you are arrested for a order of protection, you're technically eligible for a Class 4 felony. And depending on, and sometimes that those felonies can go from a Class 4 to a Class 3. A Class 4 is, you can get probation and punishable up to 1 to 3 years in prison. And that's also true of a domestic battery, where the domestic battery, you cannot get supervision for a domestic battery, but after your first conviction of a domestic battery, if you get arrested and again, you will be eligible to be charged as a felony based on that prior. And that's true of violation of border protection as well. That's kind of the short version of it.
Okay. Wanted to bring Andrea into the discussion.
Thank
so, so as a practitioner representing individuals in divorce and in domestic violence cases, are there any considerations that you evaluate with the client when perhaps they're looking for exclusive possession, but there's also an element of domestic violence, but maybe it's a you know, not to the level where you're not confident that an order will be entered, and where you might proceed with the case first.
Yes, every case is very different, but in my experience, if you're trying to get exclusive possession through the divorce court, it is much more difficult and the burden is much harder. So really under the domestic relations court, in order to get exclusive possession of a home, you really have to show that the physical or mental well-being is in jeopardy by continuing to be occupying in that home. It's difficult, it's long, it's not a sure result. And unfortunately, many people who don't feel safe end up living together. So when someone truly has a domestic violence situation, I do try to recommend that they go through getting an order of protection before the divorce if possible. And if not, the cases generally speaking, and I think Judge Rice can speak to them, if they're brought through the domestic violence and there is a divorce matter, they will be consolidated into one case. And in those events, I find it easier to work with an exclusive possession situation. So those are my thoughts.
Okay. I do have some other questions, but I see that we have a lot of people submitting questions. So I wanted to maybe start with a few of those, and that might see how much time that takes up. We have about a half hour left, or 25 minutes.
Scott, do you want me to help out with those, or have you got it?
Yeah, I think I could start off here.
Okay.
Looking at a few of them. So there was a question that asked, Sylvia, you mentioned there's 5 areas that are the charges can be brought with a violation of order of protection. And I think what you're referring to is under section 214 of the Domestic Violence Act. There's certain remedies. So that's just
Right. So
go ahead.
Yeah. So if you look at, I don't know if anybody has access to the orders of protection, but there's, it's, the first one is paragraph 1, and that's where what the respondent is prohibited from, like committing, and those areas are physical abuse, willful deprivation, harassment, neglect, interference with personal liberty, exploitation, intimidation of a dependent, and stalking. The second one is that, once you're like, we were just talking about granted exclusive possession and they are not enter or remain at the household. And then there's usually an address. And then there's paragraph 3, and A is the respondent is ordered to stay away from petitioner and other protected persons, including but not limited to refraining from telephone calls. And that's like, and there's like a list of ways to contact person. And then there's 3B, which is different from paragraph 2, is that it's the respondent is prohibited from entering or remaining at a location when the protected parties are present, which those are 2 separate remedies. And usually in 3B, it's home, it's the schools or place of work or things like that, not necessarily somebody's home. The next provision is number 14, which is where the respondent, sometimes people choose to allow to have the defendant around, but they don't want that person under the influence of alcohol or other drugs. And this is always a tricky provision, because a lot of people think it's just the defendant is prohibited from entering or remaining in the household while intoxicated, but it also, there's the additional element is that the defendant also has to be constituting a threat to the protected parties. So some people leave the courthouse thinking that, oh no, this person can't get drunk or high anymore. That's not it. There has to be, it's twofold. They can't be intoxicated, and they have to be a threat to the protected parties, which I think sometimes people don't necessarily understand. And the last one is that when they're orders to surrender all their firearms to the police, and they don't surrender the firearms.
Okay, thank you. A couple people raised questions about when the respondent has third parties contacting the petitioner. So these are, from my experience, respondent's mother's calling the petitioner saying, hey, why don't you drop it? You're hurting him at work, or hurting her at work, things like that. So I wanted to start off with law enforcement. Is that, how do you treat those type of violations, if it's any different than the other examples that we used? I know in the criminal statute, it does provide specifically that if the defendant is doing any of the violations through third parties, it's also actionable criminally. But what if that's going on and they contact, the police? Start with Sergeant Evans.
We're still going to investigate that like any other violation. We would want them to contact us, let us know about it. And again, if we have to do any type of digital investigation, like subpoenas for phone records or location services, we will do that.
Okay. Same thing with you, Aileen?
Yes, same thing, Scott. But I also want to add, while there's those 5 criminally enforceable remedies, there are a bunch of remedies available on an order of protection. And in Chicago, I don't know if it's the same in Highland Park, we still want you to call and get a case report so we can document those in a case report. It would be a violation of an order of protection case report, non-criminal. So those are the return to court situations and go before the judge. But I really just don't want folks walking away. And I know sometimes community thinks, oh, if it's only those 5 remedies, that's the only time we call police. Please call police, whether it's 911 or 311, depending on the situation. Please make sure you're calling for any violation of an order of protection.
Okay.
I totally agree. I probably should have said that, but that's absolutely true, because a lot of the other remedies will, if they're not reported, they sometimes will escalate to the more serious remedies. And I think just calling the police, like both officers said, that just you should call the police if you believe that there's any violation of any sort, and just to protect yourself, because it's really not up to the domestic violence victim to determine whether or not these violations are criminal. And I just think better to be safe than sorry is always to call the police. Of course, go somewhere safe, call the police, and just make sure you protect yourself first.
I could just add into that in the divorce context, that if you feel that you're unsafe in your home, but you hadn't called the police, it's often used as like, well, things aren't that bad. And so I do think it's helpful to have that record.
Judge Rice, you mentioned when filling out the paperwork as a petitioner, you don't have to list your own address, but you do need an address to receive. Somebody asked if an email address would suffice as an address, or do you need to have a physical address in the paperwork?
There has to be some physical address, some mailing address that things can be sent to as well as the email address.
Okay. This question, let me read this one. It says, if someone is in the process of a divorce and there's an order of protection already entered, and the person who the order of protection is entered against violates the order of protection, and then as incarcerated, does it slow the divorce proceeding? Would it slow the divorce proceeding?
I'll
Okay.
take that answer. In
Sure.
theory, it should not slow the divorce proceeding, and you can get divorced while someone is incarcerated. Reality, a lot of things get slowed down in the divorce process, and I think you have to have service through the jail and other things like that, but it should not slow down the process and should not affect your ability to get divorced.
Okay, so this question's, I think everyone may be able to participate here. Are there any volunteer opportunities for attorneys to assist victims with order protections, in any way, whether it's preparation, whether it's advice, things like that? Maybe start with you, Judge Rice.
I love that question. Yes. We are looking for you. Please contact my office or me. I'll type my number into the chat, because we did have a couple of attorneys helping us with some law students, but we would love to have attorneys volunteering to help us, because we have so many people that come in to 555 West Harrison. We're getting probably about 50 to 60 litigants a day filing petitions. And they have such a difficult time sometimes writing their affidavits, explaining what happened. And the better those look going up to the judge, the more likely they're going to be successful in getting an emergency order of protection. And we have computers right on the first floor where they can sit and get onto Aleo and do it electronically. And sometimes people are really cautious about getting on those computers. So if we had attorneys here to help us with that, that would be fantastic. So I'm gonna go into the chat and put my number.
How about from law enforcement side, any opportunities for volunteers to help domestic violence victims? And Vicky, you could probably chime in on this maybe as well.
I think I mentioned Highland Park Highwood has a pretty robust legal aid clinic, and I know they're always looking for volunteers to help out.
And I would say specific to our program of officer-involved domestic violence, it's really challenging sometimes for victims of Chicago police officers for me to be able to get them pro bono, experienced, willing to help attorneys, because this can be a really big mess. They can be really messy. So anyone who might be willing to work with a little bit more challenging case, please let me know.
This question, Judge Rice.
Wait,
Oh, go ahead, Vicky.
I'm coming in. I'm
Yeah.
coming in. I'm not sure where my video
Sure.
is, but you don't need to see me. I would make a plug, not only, you know, there are certainly North Suburban Legal Aid has, I think, opportunities, Ascend Justice, Lifespan. Those are kind of the agencies. There are more legal aid agencies that might take a volunteer attorney. But I would also make a plug for SHALVA's own legal liaison program. We are always looking for family law attorneys. As important as today's program is on orders of protection, it is just one small piece of the puzzle. When you're dealing with domestic abuse, and many of our clients do need family law attorneys to help them out, not just with OPs, but also with divorce proceedings. And I just want to give a shout out to both Scott and Andrea, who have each represented SHALVA clients in the past. And we really appreciate it, but we always need more help. So
Yeah.
thank you for asking the question.
I want to echo that too, Vicky, for Scott and Andrea, and particularly for Schiller, DeCanto, and Fleck, and what they've done for us here at the DV court already as well, and being participants on the DV committee and helping us in our recommendations. So thank you both for that.
Judge Rice, this question, as I was going to mention this when you were talking about the overnight extended hours, but how is, if somebody doesn't speak English and needs an interpreter, how is that handled?
Yeah, right now we're using Language Line, and so we'll call through to a special number that we have for Language Line. One thing we have learned is that Language Line has a different connection for Zoom that the county, we did not realize the county didn't have. So we've been just doing the old-fashioned way and putting the Language Line person up to the Zoom like this, and that's not the most efficient way. So we'll have to get that in place, but that's how we're doing it right now. We use Language Line.
This question also would be applied to you, Judge Rice. If the sheriff is, how many attempts, if you know, does the sheriff attempt to serve an initial emergency order? And what happens if they're unable to do that when they, in the 21 days when you come back on that emergency order?
We usually use make 3 sheriff attempts. I usually will issue 3 alias summonses for the sheriff to go out. And we're constantly probing the petitioner. Can you give us mom's address? Can you give us a sister or brother's address? Can you give us a work address if the sheriff can't find them at the home address? If we, after all of those tries, can't get the person served, we can move it to publication. And through publication, they can get a default order. That's our last result, because I hear anecdotally sometimes that law enforcement is more hesitant to violate someone on a default order than one that has been duly served. So we try to get the person served. Another thing the party can do is try to get a special process server. That presents another problem on the back end as well, because we have to have a judge order those into leads, because only those orders that the sheriff served get into leads. And but any way that the person can try to get the person personally served is going to be a better outcome.
Okay. This question would be for you, Sylvie, and I had a kind of a question that goes along with this. Somebody asked how many violations of order protections are needed to upgrade to a felony, and I had a kind of a similar question to that as well. If somebody is a recipient of a, let's say, a voicemail from the respondent 7 days in a row, and it's no doubt that it's the person, you can prove that. Are those 7 different violations, and are those 7 separate charges, or how are those handled if it continues, day after day?
I mean, quite frankly, from a prosecution standpoint, you can handle that a couple different ways. It can be one charge where it's a continuing course of conduct. We can also technically charge it in 7 different cases. It kind of depends on, at the time, how they're investigated and how they're charged through the court system. What makes a violation of order protection upgradable to a felony is a conviction. It's not necessarily how many times they're arrested, but the defendant has to be convicted, and it cannot be a supervision. It has to be an actual conviction, like probation, conditional discharge, or a jail sentence of some sort. It's the conviction, not necessarily the charge of the violation of order protection. Also, it's upgradable if they, like, let's say they have a violation and the defendant has a prior domestic battery conviction. That's the same that also would upgrade that person to a class 4 felony, not including the domestic battery there are felony domestic battery charges that are completely separate from like an upgrade. I'm talking about some things that would normally be a misdemeanor that could be upgraded based on multiple convictions.
Okay, this next question would be, I think, go to Aileen and to Sergeant Evans. Is there a process for a private attorney who's representing a victim of domestic violence to work with you, and are you receptive to that, to try and move towards a criminal charges and a criminal prosecution of the abusing party? Is there something that the person's attorney can do to assist or to work with you in moving that forward? Maybe start with Aileen.
I was going to let you start with a charge. So I'm not exactly sure that would be, but on its surface as it stands, no. I mean, best they can do is support the victim. If we're doing some kind of interview, if they want to be present, we can do that. Safety planning, all that kind of stuff, that information we want to get victims, but we are not at liberty to, kind of discuss this type of information with a private attorney. I don't know if Highland Park's different, but that's kind of the down and dirty on that one for me.
How about Highland Park?
I would agree. We wouldn't be at liberty to discuss everything, but we do get contacted by attorneys very often here for a variety of domestic related issues. So that's not uncommon for us to speak with, to have an attorney contact us, want to speak with an officer or a supervisor.
Okay. Judge Ray, somebody asked if the extended hour program may be extended to other counties or other areas of Illinois. If you're
I don't. I know that Winnebago County was trying something like this, and actually did this for a while. I don't know if they still are. They didn't do it the same way that we have. There are other municipalities throughout the country that do this. There are about 4. I know they are doing it in Arizona, but most jurisdictions did it a little differently than we have. They had a screening process, either through an advocacy group or the police department. And our advocacy community here did not want the cases to be screened. They wanted people to be able to come to us directly. And so that's where we're a little cutting edge,
Okay.
we say. So
for law enforcement, oftentimes, and this happens a lot, I think, in dissolution of marriage cases, it starts off as a domestic violence petition, and the parties end up agreeing to vacate that, and they enter a mutual stay away order. It's called different things, sometimes a mutual injunction. What is the role of law enforcement if that is being if there's an order that says, it's not an order of protection, but it's a state court order that says, respondent is to stay away from the petitioner or not harass that person, and they're doing that. How and to what extent would law enforcement get involved in that? And I'm sure you've been confronted with those sort of orders many times in the past. So how about you, Sergeant Evans? What?
We're going to document it again if it's something that there's no criminal remedy. The big thing for us is we're going to write a report. Officers are going to obtain information, make sure there's nothing that's criminal in nature. And we do see that a lot. The orders of protection are ruled into the dissolution case. So we deal with that very, very, very frequently. So again, contact us, let us know. We're going to make a report.
And I would just echo that I do think, and I said this earlier, getting the report is very important, because I'm not sure in the domestic cases you can just have a criminal resolution. But if things get worse, to have that report that you called and reported the violation will be very helpful to you.
Is this a similar, Aileen, in Chicago with those no contact orders?
Yes, I despise those orders for all of you on the line. So I do want to say that if you're working with someone getting an order, please explain to them that it is not criminally enforceable, because we do have a lot of folks who get those orders and then they're surprised we can't effect an arrest, unless of course a crime was committed, but we can't effect an arrest depending upon what act occurred in that type of order. But same thing in Highland Park, we're going to generate a non-criminal case report and we're going to refer that victim to go back to the court where the order was issued. But please, please, please explain to the people that you work with the difference between going from an order of protection to this mutual, stay away by mutual agreement.
Yeah, I think I exhausted the questions in the chat, at least the ones that I saw. We have like 5 minutes left. I don't know if anyone on the panel has maybe some final words of advice or input on these issues.
Can I just say one thing? I know, because
Sure.
we were talking about lawyers volunteering. I don't know about other courthouses, but in the Markham courthouse, there's 2 domestic violence agencies, South Suburban and Crisis Center, and they have advocates that work to help pro se litigants file their orders of protection. And if those of you out there who aren't lawyers, and I know that, I've worked with those advocates when I was a very young lawyer, and they helped me a lot to learn, through their experience, they know a lot about how orders of protection work. So if you're interested in volunteering that way, I know there probably there's a domestic violence agency in your area, wherever you live, that may have programs similar to that to help pro se litigants to, write out their own orders of protection. I know they have it in the Markham courthouse.
Anyone else have any closing remarks? If not,
I just want to thank everybody here. We've got a lot of good partners working with us on domestic violence issues, and I want to thank Aileen Robinson particularly, because Aileen was in the forefront of helping us to change our victims notification, the DEN. Remind me again what DEN stands for, Aileen.
As you bring that up, Judge, domestic incident notice.
All right, and so on the notice, it gives a lot of information to victims, and it also gives information on our after hours program. And so we got that rewritten, and so now all of the Chicago police officers have a lot more information on the notice. And so, we're just best case scenario with partners with us right now. And I just want to let everybody know how much we appreciate it.
And if I could just take a minute and thank you all. This has been an amazing panel, an amazing discussion, and I'm going to do our selfless plug. For those of you in Chicago, we come out all the time and explain police response and what we do. We do training, it's free. But in addition to that, we have this beautiful purple and white brochure called the Chicago Response. And what I really like about this, and if you go on my website, it's the old one, so please don't do that, email me. It tells you what police officers must do on the scene. So I know that's kind of even a step before talking about orders of protection, right? So what rights, what do we have to do to support victims? How we're going to make an arrest, how we determine who should make an arrest. And I think by educating yourselves, you're really helping victims in knowing. Someone might come to you and say, it didn't feel right. The police didn't do this, or the police did that, or how do I know what's going to happen? So I really love educating community on what police can and can't do. So if you're interested, you can email me. I'll send you a newish one. Newish meaning things here are always changing. But if you have opportunities, myself or someone from my team can come out and kind of walk you through a police response in Chicago for domestic violence.
And I want
So if it's okay with all the panelists, I'm going to be sending out the slides afterwards. Maybe I'll also send out contact information for each of you. And so the emails will be available. Okay, and I just want to, before you close up, Scott, I want to thank everyone on the panel today for your time and dedication and devotion. It's especially important during Domestic Violence Awareness Month, but it's important every day. And I would ask people if they can help out by completing our survey. I have the link right there. I'll put up a slide when we're finished so people can use the QR code as well to get in there to take it. But thank you so much.
Yeah, and I wanted to thank the panel. I had a conversation with Vicki several months ago about putting together a program like this, and I couldn't have imagined what an incredible panel we put together to put this on. And thanks to SHALVA for hosting it, and thanks to everybody who joined us today. We had a lot of people sign up, which was great, and I hope that everybody viewing it got something out of it or learned something about the process that's going to help them in their practice or help them seeking protection in the future if they need to. And that's all I have. It's a wrap.
Okay, I'm going to share my screen.
Okay,
Thank you.
thank you.
Thanks,
Thanks.
everyone. Be
Thank
safe.
you.
Be safe. Bye-bye. Hey.